Hi, I'm John Labella with Alex Partners. The one big thing, COVID impact on internal controls over financial reporting. Every company has had to shift how it conducts everyday business functions on a global scale, and the rapid pace applied to set up new virtual processes exposes companies to risks they likely hadn't contemplated in their current control environment. And if there are sufficient compensating controls put in place to address the new processes, they are surely more time-consuming and untested, resulting in the temptation to take the path of least resistance and circumvent or deviate around those new controls. Information flow to allow for accurate disclosures is pressured by modified sales and cost changes, goodwill and intangible valuations, going concern, etc. All of this putting management in a tough spot under these COVID times. It'll be interesting to see how enforcement weighs the failures that evolve during these times and how it contemplates the efforts of entities to adapt to the pressures. Have a good conference.
Welcome back. So we have a great keynote up next that I'm really looking forward to. A benefit of a virtual event is that you can invite the best speakers in your field to join you, and they don't need to travel to participate. So throughout the day, we've heard different panels discuss the impact of COVID-19 on the securities enforcement and litigation world. And now we're going to hear directly from the top enforcement official at the SEC on that very subject. I'm very honored to be joined by Steve Peikin, who is the co-director of the SEC's Division of Enforcement, and he's going to discuss the Division of Enforcement's response to the COVID-19 emergency. From 1996 to 2004, Steve served as an assistant U.S. attorney in the Southern District of New York. He was chief of the office's Securities and Commodities Fraud Task Force, where he supervised some of the nation's highest profile prosecutions of accounting fraud, insider trading, market manipulation, and abuses in the foreign exchange market. And more recently, Steve was managing partner of Sullivan Cromwell's Criminal Defense and Investigations Group. Steve, thank you so much for joining us today, and welcome, and really looking forward to your remarks.
Hey, thanks very much for that kind introduction, and thank you for inviting me to speak here this afternoon, Bruce. Before I begin, I'm required to give a standard disclaimer that the views I express here today are my own and don't necessarily represent the views of the Commission or staff. So we're all far too familiar with the many ways in which the COVID-19 pandemic has transformed our personal and professional lives over these last several months. We're confronting new and serious personal challenges, all the while endeavoring to continue our respective professional responsibilities. Like most of you, the SEC staff have been teleworking since March. The disruption and changed work environment has had and will continue to have a substantial impact on the activities of the Division of Enforcement. But I'm gratified to report that we've continued to execute on our important mission to protect investors, promote capital formation, and maintain fair and orderly markets. So this afternoon, I'd like to share with you how the Division of Enforcement is responding during this ongoing crisis. I'll describe some of the work we're doing to detect and address COVID-19 related misconduct. And then I'll turn to our regular docket of investigations and litigations. I'll close with a brief discussion of where I see the division going from here. So like our colleagues across the Commission, we in the Division of Enforcement have focused significant time and resources on responding to COVID-related matters. In organizing our response, we've looked to the experiences had and the lessons learned by our predecessors in other periods of emergency and serious market disruption, including the September 11th attacks and the 2007 to 2008 global financial crisis. One of those essential lessons is the importance of a well-coordinated response. And to that end, in late March, my co-director Stephanie Avakian and I formed a coronavirus steering committee to coordinate the Division of Enforcement's response to coronavirus-related enforcement issues. The steering committee comprises approximately 24 leaders from across the division, including representatives from our various specialized units, from our home office and the regions, and from our Office of Market Intelligence. The committee's mandate is to proactively identify and monitor areas of potential misconduct, ensure appropriate allocation of our resources, avoid duplication of efforts, coordinate responses as appropriate with other state and federal agencies, and ensure consistency in the manner in which the women and men of the division address coronavirus-related matters. The steering committee is focused on identifying key areas of potential market and investor risk. One area that we immediately identified is microcap fraud. Other public health crises and national emergencies, such as Hurricane Katrina in 2005 and the Ebola crisis of 2014, were followed by efforts by microcap fraudsters to make specious claims about treatments and disaster response capabilities and the like. Sadly, but not surprisingly, we've seen an explosion of similar activity over the last few months. To combat these potential frauds, the steering committee is coordinating with the division's Microcap Fraud Task Force and the Office of Market Intelligence to rapidly gather and analyze market intelligence in the microcap space and to quickly triage matters for potential trading suspensions or enforcement actions. I'll discuss these in more detail in a moment. The COVID-19 crisis has resulted in dynamic and volatile markets not seen in decades. These market conditions, along with a regular stream of potentially market-moving announcements by issuers, provide increased opportunities for insider trading and market manipulation. And to detect such misconduct, the steering committee is working with the division's market abuse unit to monitor trading activity around announcements made by issuers in industries particularly impacted by COVID-19 and to identify other suspicious market movements for possible manipulation. Previous economic downturns prove that stresses on the financial conditions of issuers may raise the risk to investors from financial statement and issuer disclosure frauds in two ways. One, by exposing pre-existing accounting or disclosure improprieties, or two, leading issuers to engage in improper conduct. As a result, structural risks such as excessive debt, extreme leverage, and possible liquidity disruptions could be indications of potential issues. Recognizing that the economic impacts of any downturn may vary across different industries and sectors, the steering committee has developed a systematic process to review public filings from issuers in highly impacted industries, with a focus on identifying disclosures that appear to be significant out of step with others in the same industry. We're also looking for disclosures, impairments, or valuations that may attempt to disguise previously undisclosed problems or weaknesses as coronavirus related. The steering committee is also focused on the ways in which COVID-19 may affect regulated entities and individuals. For example, in conjunction with the division's asset management unit, the committee is monitoring the investment advisor and investment company space for failures to honor redemption requests at both private funds and registered investment companies, which can indicate an underlying issue. The steering committee is working with our complex financial instruments unit to monitor the impact of the crisis on the performance of complex structured products and to identify possible improper marketing and sale of such products to retail investors. The steering committee is also communicating with state securities regulators, other federal agencies, exchanges, and SROs to coordinate our parallel efforts to protect investors. Those lines of communication have allowed us to exchange information efficiently, move quickly where the facts and circumstances have warranted, and avoid unnecessary duplication of efforts. Now, this is far from an exhaustive list of the steps the committee is taking to proactively detect and investigate possible COVID-19 misconduct, but it should give you a sense of our overall framework and approach. Now, throughout this crisis, the Commission has made significant efforts to communicate with investors and market participants regarding the impact of coronavirus and the various steps the Commission and the staff have taken in response. Consistent with this approach, the Division of Enforcement has worked to provide visibility and transparency regarding enforcement initiatives to educate market participants and deter potential wrongdoers. One example is a statement that Stephanie and I issued on March 23rd, in which we noted the increased number of corporate insiders with access to material non-public information and the potential increased value of such information given dynamic market conditions. We urge companies to follow their disclosure controls and procedures to protect against the improper dissemination and use of such information. The division is also working to help educate investors on the unique risks they may be facing during the pandemic. Our Retail Strategy Task Force, in collaboration with the SEC's Office of Investor Education and Advocacy, has issued an investor alert warning of potential COVID-19 related scams targeting Main Street investors. The alert, which was just updated last week, cautions that fraudsters often seek to use national crises and periods of uncertainty to lure investors into scams, urges investors to be vigilant when considering investment opportunities, and highlights the types of frauds investors should be wary of and specific steps that they can take to protect themselves. Now let me turn to discuss some of the results we've achieved so far on behalf of investors on this front. In our March 23rd statement, Stephanie and I emphasized that the division was committing substantial resources to ensuring that our Main Street investors are not victims of fraud or illegal practices in these unprecedented market and economic conditions. The most visible manifestation of this commitment is the significant number of trading suspensions the Commission has ordered in the last several months. Trading suspensions are, by design, prophylactic. The SEC has the authority to suspend trading in a stock if in its opinion, the public interest and the protection of investors so require. In many instances, the Commission suspends trading when there are questions about whether public information about the issuer is accurate, adequate, or reliable. Because of the importance to and potentially significant impact on investors of questions about whether public information is accurate, adequate, or reliable, we're conducting these investigations on an accelerated basis. The path that leads to a recommendation that the Commission order a trading suspension often starts with referrals from FINRA, tips from investors, or from the Commission staff's own market surveillance. Because time is often of the essence, enforcement staff engage in accelerated fact gathering and analysis, analyzing public statements by and about the issuer, and reviewing trading data. In some cases, the staff may contact brokers, promoters, or others for documents or information. Where claims have been made about the contracts or new products or the like, staff may contact counterparties or others to gather facts about whether those claims are accurate. And if the staff believes a trading suspension is warranted, it makes a recommendation to the Commission for expedited consideration. The SEC may suspend trading in any stock for up to 10 business days, after which trading may resume. For stocks that trade on an exchange, quoting may resume as soon as the suspension ends. For stocks quoted over the counter, however, quoting does not automatically resume after the suspension ends. Instead, a broker-dealer generally may not solicit investors to buy or sell the previously suspended stock until certain requirements are met. Because a trading suspension results in a break in two-way quotations for more than 4 business days, it removes the so-called piggyback exception that enables many over-the-counter stocks to be quoted by market makers. And a broker-dealer may only resume quoting an OTC stock if it has a reasonable basis under the circumstances for believing the company's financial statements are reasonably current and accurate and complies with the requirements of Rule 15C211. Now, the SEC has in place a process that allows anyone adversely affected by a trading suspension to file a petition seeking to terminate the suspension order. The SEC may provide appropriate relief where the suspension expires or while the petition is pending. These petitions should be filed with the Office of the Secretary and are directed to the Commission in the first instance, and Commission decisions may be appealed to a federal circuit court. The Commission has noted that it also has the authority to provide relief from possible consequences arising from the trading suspension, such as the loss of the piggyback eligibility. Trading suspensions have been a critical element of the Commission's response to COVID-19. Since February 7th, the Commission has suspended trading in the securities of more than 30 issuers as a result of questions about the adequacy and accuracy of coronavirus-related information. These suspensions followed a broad range of claims by issuers, including those relating to access to testing materials, developments of treatments or vaccines, and access to personal protective equipment. The Commission has also suspended trading in the stock of 3 microcap issuers whose names or ticker symbols closely resembled those of unrelated companies whose products are actually relevant to COVID-19, such as companies involved in testing, production, or distribution of N95 masks, and video conferencing technology. The trading suspension is not a finding of fraud or misconduct. In many instances, the Division of Enforcement will continue to investigate whether an issuer whose stock has been suspended was engaged in potential fraud or other misconduct, and if appropriate, will recommend charges to the Commission. Because of the potential severity of the impact of this sort of misconduct on investors, we're conducting these investigations on an extremely accelerated basis. One such example is Praxin Corporation, whose stock was suspended from trading on March 25th. As stated in the Commission's order, the suspension was due to questions about the accuracy and adequacy of claims Praxin made in a pair of press releases, in which it stated, it, quote, was about having and being able to obtain large quantities of N95 masks used to protect wearers from COVID-19. That's a quote from the Commission's order. After the suspension was ordered, the staff continued its investigation And on April 28th, the Commission filed suit against Praxin and its CEO in federal court in Florida. This was the Commission's first action alleging fraud charges relating to an issuer's COVID-19 related claims, and the case was filed 61 days after Praxin made its first allegedly fraudulent statement. Civil actions that result in sanctions serve significant enforcement goals that suspensions are not designed to achieve, such as deterrence, punishment, and in some cases compensation to harmed investors. There are numerous active investigations of COVID-19 related potential misconduct, many of which are also proceeding at an accelerated pace. Now, let me turn to our non-COVID-19 related work. Stephanie and I have both spoken publicly on a number of occasions about the importance of resource allocation to our enforcement program, and the current crisis is testing us on that front. While COVID-19 related matters are a top priority for the division and the Commission, our other priorities also remain in place, and our many hundreds of investigations and litigations remain ongoing. To continue this work, we've had to adapt in the face of new challenges. Some of them are mundane, such as determining which video conferencing platforms are sufficiently secure for us to use, or how to print and serve subpoenas when we're working from home. Others are more substantive, such as under what circumstances should we seek emergency relief when courthouses are largely shut, what to do when witnesses decline to sit for testimony or interviews, or how to respond to expiring limitations periods. In the face of these challenges, I'm proud of the way the division has responded. Since the onset of the crisis, division staff have been engaged in virtually every facet of our work, from opening new cases, to taking remote testimony, to having Wells meetings, to filing litigated and settled actions, and even conducting jury trials. Before I describe some of the most significant results, I want to say a word about how we've tried to interact with the people and entities who are on the other side of our investigations and litigations, whether as witnesses, custodians, or opposing counsel. We understand that we are all confronting many of the same difficulties, regardless of where we sit. But if we in the Division of Enforcement are continue to fulfill our important responsibilities, we cannot effectively shut down our program by agreeing to a blanket hiatus in investigations or litigation. That being said, our staff has been directed to work with counsel and others to reach reasonable accommodations whenever possible. The flip side of this, which I hope goes without saying, is that we can't permit the crisis to be used as a cover for gamesmanship. One additional note on this, we are keenly focused on matters where we face expiring statute of limitations that may result in the Commission losing claims or potential remedies, such as the ability to seek penalties or disgorgement. In those instances where we were unable to obtain tolling agreements to allow sufficient time to complete our investigation, and we believe the existing record supports enforcement action, we will consider recommending that the Commission authorize an action, and will seek to supplement our evidence through civil discovery. In other words, we will do everything we can to protect the Commission's claims and remedies in the face of the challenges of this crisis. There are a few examples of our work I'd like to highlight to illustrate the continued breadth of our activities over these last few months. Since mid-March, the Commission has reached settlements resolving matters in a number of important regulatory areas, including broker-dealer blue sheet submissions and investment advisor disclosures. The Commission obtained favorable jury verdicts in 2 trials that concluded in mid-March, and it obtained a preliminary injunction against Telegram in connection with the Commission's claim that Telegram violated Section 5 in its $1.7 billion offering of digital asset securities. In an ongoing case concerning an offering of a purported digital asset that the defendants allegedly told investors was risk-free and could provide returns of up to 225,000%, the Commission won emergency relief, including an asset freeze, and then obtained a contempt order with bench warrants issued for the arrest of 2 defendants, including a former Washington state senator who had failed to appear in the proceedings. The staff has also been busy on the investigative front. Since mid-March, the staff has triaged more than 4,000 tips, complaints, and referrals, representing a 35% increase over the same period last year. In the same period, it has opened hundreds of new investigations, many COVID-19 related, but many in other traditional areas of investigative interest. Finally, thanks to the hard work from the staff of the Office of the Whistleblower and colleagues across the division, since March 23rd, the Commission has issued awards to 9 whistleblowers, including an award of over $27 million. And so while far from comprehensive, this list should give some sense of the work the divisions continue to do on behalf of investors. So finally, what lies ahead? Obviously, much is uncertain. We do not know how long this crisis will last or what its ultimate impact will be. I do expect the Division of Enforcement will continue to do its work, and its ability to function remotely and virtually will continue to improve. I expect there will be more trading suspensions related to COVID-19 and more fraud cases related to potential COVID-related investment scams. And if history is a guide, the recent market decline and continuing economic stress may well reveal past misconduct or result in new misconduct that becomes the subject of enforcement investigation and potentially recommendations for enforcement action. But it's really too soon to know much more than that. Before I close, I just want to say a few words about our staff. All the accomplishments I've discussed, the trading suspensions, the new actions, the settlements, the jury verdicts, are due to the incredible job the staff of the Division of Enforcement have done under extremely difficult circumstances. Among the logistical challenges posed by an all-telework environment, including in many cases the sudden need to be a full-time caregiver for children or others, in addition to being a full-time enforcement attorney, accountant, or other team member, our staff have functioned at a high level. Many of our staff have shown great willingness to pitch in on various projects on top of their investigative work, and they've demonstrated resourcefulness and creativity in handling their cases. Most of all, they've shown a level of camaraderie and concern for their colleagues and their communities that's inspiring. In the spirit of finding a silver lining to a particularly dark cloud, I believe that we have learned lessons that will benefit the division, the commission, and the investing public long after the COVID-19 crisis is hopefully a distant memory. With that, I want to thank Bruce and our hosts at the Securities Enforcement Forum. I'm glad we were able to proceed with this program, notwithstanding the unprecedented logistical obstacles. And I thank you all for listening today. I'm grateful that you were able to join me. So thanks for your time, and please take good care of yourselves and your loved ones.
Thank you, Steve. That was terrific. We greatly appreciate your public service in this emergency and that of the staff. And we're grateful for your time and your insights here today. Thank you. We're going to resume with our directors panel at 1:15 Pacific. Thanks.